Located in East Jerusalem, Al-Aqsa Mosque compound, or Haram al-Sharif, is among the holiest sites for Muslims around the world. Therefore, its sanctity as a Muslim shrine must be upheld as sacrosanct at all times. The historical status quo at the holy places in Jerusalem, including in Haram al-Sharif, was established during the Ottoman era and has remained in place ever since. On 4th of April 2023, Israeli security forces stormed the Al-Aqsa mosques, beat up worshippers, and detained hundreds of them altogether during the holy month of Ramadan. This kind of brutal practice is becoming commonplace. While Muslim worshippers face the treatment above, Israeli security forces continue storming the Haram al-Sharif to provide shelter for the Jews who enter the compound in breach of the historical status quo. In addition to the holy places, the status of Jerusalem itself is also a main issue. As a result of well-known developments, the State of Israel was proclaimed on 14 May 1948, and the ensuing conflict resulted in Israel controlling more land than envisaged under the UN General Assembly Resolution 181 of 29 November 1947. An armistice line, known also as Green Line, came into being. On 5th of June 1967, Israel launched a military offensive and occupied the Gaza Strip, the West Bank, and East Jerusalem illegally. In the following period, several UN Security Council and General Assembly resolutions affirmed that acquisition of territory by military conquest is inadmissible under the international law, and confirmed that all legislative and administrative measures and actions taken by Israel which purport to alter the status of Jerusalem, including expropriation of lands and properties thereon, are invalid and cannot change the status. Furthermore, the UN Security Council condemned in the strongest terms all measures taken to change the status of the city of Jerusalem. United Nations General Assembly, in its resolution of 4th of July 1967, also considered measures taken by Israel to change the status of the city of Jerusalem totally invalid. It called upon Israel to rescind all measures already taken and to desist forthwith from taking any action which would alter the status of Jerusalem. UN General Assembly Resolution of 14th July 1967 also reiterated this call. On 30th of July 1980, Israeli Parliament adopted Basic Law titled Jerusalem, the Capital of Israel, proclaiming the complete and united Jerusalem is the capital of the State of Israel, which asserted a clear change into the character and status of the city of Jerusalem. In response to this illegal act, the UN Security Council resolution, I repeat, UN Security Council, not General Assembly, the UN Security Council resolution 478 in 1980 affirmed that, I quote, the enactment of the Basic Law by Israel constitutes a violation of international law and determines that all legislative and administrative measures and actions taken by Israel as the occupying power, which have altered or purport to alter the character and status of the holy city of Jerusalem, and in particular, the recent Basic Law on Jerusalem, are null and void and must be rescinded forthwith. UN Security Council also censured, condemned in the strongest terms the enactment by Israel of the Basic Law on Jerusalem and the refusal to comply with relevant UN Security Council resolutions. Furthermore, the Council decided not to recognize the Basic Law and such other actions by Israel that, as a result of this law, seek to alter character and status of Jerusalem. In the same way, General Assembly, in several resolutions regarding the adoption of Basic Law, expressed its strong rejection of any changes to the status of Jerusalem. Also, the resolution adopted by the General Assembly on 30 November 2022 called upon all states, consistent with their obligations under the UN Charter and relevant Security Council resolutions, following. A. Not to recognize any changes to the pre-1967 borders, including with regard to Jerusalem, other than those agreed by the parties through negotiations, including by ensuring that agreements with Israel do not imply recognition of Israel's sovereignty over the territories occupied by Israel in 1967. B. To distinguish in their relevant dealings between the territory of the State of Israel and the territories occupied since 1967. Although some states deviated from these commitments, the resolutions are still valid and must be upheld. The UN Security Council and UN General Assembly resolutions cited above illuminate how the UN bodies and international community see the Israeli unilateral actions in the occupied Palestinian territories. Mr. President, distinguished members of the Court, basically, Israel is the occupying power in the occupied Palestinian territories and under the obligation to abide by international law. Therefore, any Israeli acts and or measures executed in the occupied Palestinian territories in breach of international law should be considered null and void. The practices, as well as acts and measures violating human rights, must be held to account. The same especially goes for the policies and practices of Israel in Jerusalem and the holy places. Any Israeli act and measure aimed at altering the character and status of the city of Jerusalem and of the holy places, including Haram al-Sharif, should be considered null and void and must be ended to rescind immediately. I focused on these points because Turkey is deeply concerned by the unilateral policies and practices of Israel which violate the historical status quo in Haram al-Sharif and attempt to set a precedent to divide it temporally and spatially. Turkey also rejects unlawful, illegitimate and provocative measures that de facto restrict free access of Muslims into Haram al-Sharif. This is not only a breach of the historical status of Haram al-Sharif, but is also a violation of basic human rights of Muslims in the occupied territories. Following provocations by certain members of the Israeli government, at the meeting of the Security Council held on 20 February 2023, the President of the Security Council reiterated the call for, inter alia, preserving the status quo at the holy sites in Jerusalem. I quote, "The Security Council calls for upholding the unchanged historic status quo at the holy sites in Jerusalem, in word and in practice, and emphasizes in this regard the special role of the Hashemite Kingdom of Jordan," unquote. But in total disregard of the international calls for upholding the historical status quo at the holy sites in Jerusalem, certain Israeli ministers continue violating the sanctity of and the historical status quo at the holy sites. In 2023, just before October 7, thousands of Israeli extremists and settlers stormed into Al-Aqsa Mosque complex during the Jewish holiday of Sukkot, mainly in response to the heinous calls by the Israeli politicians. Several resolutions of the United Nations Human Rights Council also expressed grave concern at the restrictions imposed by Israel that impede the access of Christian and Muslim worshippers to holy sites in the occupied territories. Human Rights Council resolutions demanded Israel, as the occupying power, cease all illegal actions in the occupied Palestinian territories. These include excavations in and around religious and historic sites, and all other unilateral measures aimed at altering the character, status, and demographic composition of the territory as a whole, all of which have, inter alia, a grave and detrimental impact on the human rights of the Palestinian people and the prospects for a just and peaceful settlement. Access to and protection of places of worship and holy sites, as well as excavations beneath and around Al-Aqsa Mosque, have also long been subject of concern and recommendations of several human rights treaty bodies. The protection of the status of Jerusalem and the holy sites is important not only for the maintenance of the peaceful coexistence tradition among communities there from different faiths since the Ottoman era, but also for observing the sensitivities of billions of people around the world. Mr. President, distinguished members, the scope of the Israeli-Palestinian conflict and the status of Jerusalem is surely wider, ranging from settlements to transfer of Israeli settlers to the occupied territories, confiscations of land, demolition of homes, and displacement of Palestinian civilians in violation of the international law. Today, the unfolding situation in the Gaza Strip and the West Bank is extraordinary, extremely dangerous, and if left unchecked, runs the risk of threatening not only regional, but also global peace and security. I would like to emphasize once again that Turkey strongly and clearly rejects and condemns all attacks against civilians. Civilians must be protected at all times and under any circumstances. Since October 7, more than 30,000 Palestinians have been killed so far in Israel's indiscriminate attacks on Gaza. Most of them are women and children. 2.3 million civilians have been placed under full blockade by Israel, depriving them of their basic needs to survive, such as water, food, medicine, fuel, and electricity. Hospitals, refugee camps, schools, places of worship, churches, and mosques have been targeted unsparingly. Around 2 million Palestinians have been forcibly displaced. Israel's attacks have turned into collective punishment. In the West Bank, 400 Palestinians have been killed by either Israeli settlers or security forces in the past 4 months. As a matter of fact, 2023 has been the most violent year in illegal settler terrorism and violence against the native Palestinians in the West Bank. Representatives of relevant UN agencies, as well as UN Human Rights Council special rapporteurs and mandate holders, have published various reports so far on violations of inalienable rights of the Palestinian people by Israel. The current trajectory risks a broader regional conflagration as well as intercommunal polarization. Furthermore, rising threats of Islamophobia, anti-Semitism, and extremism all around the world must also be taken into consideration. As the injustices and the double standards that the Palestinians have been subjected to for decades continue, the reaction from the peoples of the region and beyond will only multiply. In other words, we must hold accountable before the law those responsible for their attacks on civilians. Otherwise, such outrageous behavior might be emulated elsewhere in the future. Therefore, reinstating the rule-based international system is a must. In view of the foregoing arguments and recalling the relevant resolutions of the UN General Assembly and Security Council, the Republic of Turkey respectfully calls upon the International Court of Justice to declare the policies and practices of Israel in the occupied Palestinian territories, including East Jerusalem, illegal under the international law. Israel must also respect the historical status quo in the holy places in Jerusalem. Again, it is ever more important as we approach the holy month of Ramadan this year, while the Israeli attacks in Gaza and the West Bank continue. It is alarming to see reports regarding plans by the Israeli government to limit the prayers of the Muslims on Haram al-Sharif during Ramadan. The provocative rhetoric by certain Israeli ministers is also worrisome. Therefore, those who have conscience and morality must step in without delay. The Republic of Turkey will continue its efforts to contribute to the permanent peace between Israel and Palestine, more urgently for a lasting ceasefire in Gaza and immediate, unhindered flow of humanitarian assistance into Gaza. Drawing lessons from past experiences, Turkey has also been developing the idea of a guarantee mechanism so that future negotiations could be held in a sound environment, and once achieved, a final settlement would hold for decades to come. The Israeli-Palestinian conflict has been at the top of the agenda of both UN General Assembly and the Security Council almost since the foundation of the UN. The UN, with its organs, following its primary responsibility of international peace and security, has adopted dozens of resolutions in relation to this conflict. It is crucial that the Court issues an advisory opinion in response to the questions in the resolution adopted by the UN General Assembly. The Republic of Turkey reiterates its firm support to a negotiated two-state solution based on the UN resolutions, thus the establishment of an independent, sovereign, and contiguous state of Palestine on the pre-5th June 1967 lines, with East Jerusalem as its capital. Mr. President, distinguished members, not to repeat the previous speakers, we focused on specific subjects here. But after listening to the previous speakers in previous days, we are of the opinion that there is solid and efficient legal framework to declare the Israeli practices illegal and to contribute to this peace. Thank you very much.
I thank the delegation of Turkey for its presentation. I invite the next participating delegation, Zambia, to address the court, and I call upon Mr. Marshal Mubambe Mushende to take the floor.
Mr. President, Justice Nawaf Salam, distinguished members of the court, as you have mentioned correctly, Your Lordship, My names are Marshal Mubambe Mujende, State Counsel, and I'm the Solicitor General for the Republic of Zambia. I have come with my team, which includes His Excellency Mr. Sylvester Mundanda, who is the Ambassador of Zambia to the Benelux countries, which includes Belgium, Netherlands, and the Luxembourg. I also have with me the team that is on record with you. Allow me to proceed. Your Lordship, I have the honor and privilege to make a submission on behalf of the Republic of Zambia on the request for an advisory opinion of this court concerning the legal consequences arising from the ongoing violation by Israel of the right of the Palestinian people to self-determination from its prolonged occupation, settlement, and annexation of the Palestinian territory occupied since 1967, including measures aimed at altering the demographic composition, character, and status of the Holy City of Jerusalem, and from its alleged adoption of related discriminatory legislation and measures. My delegation appears before this court as Zambia's unwavering commitment to peace and the principles of international law, which underpin the international system. We recognize the humanity and dignity of all individuals affected by the conflict, irrespective of their nationality or ethnicity. Mr. President, the Republic of Zambia did submit its written statement to the court in July of 2023, and we shall rely on the same. With leave of court, however, allow me to augment with oral submissions which are in support of the written submissions alluded to. Mr. President, we have carefully looked at the question that has been posed to the court, and we submit at the very outset that the Republic of Zambia recognizes the court's jurisdiction to render advisory opinions in accordance with Article 65 of the United Nations Statute. As it did in the advisory opinion on the legal consequences of the construction of a wall in the occupied Palestinian territory in 2004. We, however, make the case that the question posed to the court this time around is more complex and requires Solomonic wisdom to obviate rendering an opinion that may exacerbate rather than resolve the complex and nuanced situation which both Palestine and Israel find themselves. The Republic of Zambia has been consistent and continues to advocate for relentless efforts aimed at achieving peace in the Middle East based on the principles of the two-state solution, and we shall revert to this issue later. Mr. President, Zambia will rely on the following legal framework in making its arguments. That is to say, number one, the United Nations Charter. Number two, the Statute of the International Court of Justice. Number three, let me just say the Oslo I Accord, instead of regurgitating the full citation. Number four, the Oslo II Accord. And number five, we rely on the advisory opinion which this court rendered with regards to the consequences of the construction of the wall in the occupied Palestinian territory in 2004. Number 6, we also rely on the United Nations Security Council resolutions 242 of 1967 and 338 of 1973. Mr. President, we recognize the inalienable right of the Palestinian people to self-determination. We also recognize the legitimate security needs of the Israeli people. Both Israel and Palestine have a duty to respect international human rights law and international humanitarian law. Therefore, any recourse to the conflict should not be one that puts the blame squarely on one party, but rather one that advances a negotiated solution that culminates in a two-state solution. May it be on record, my Lord, that our support for the Palestinian people's right to self-determination remains steadfast, echoing our consistent position within the United Nations. However, it is imperative to approach this issue with a comprehensive and balanced perspective. Zambia believes that any declaration addressing the Israeli-Palestinian conflict must acknowledge the complexities and nuances inherent in the circumstances and the need to take serious consideration of the difficult situation that both parties find themselves as they strive to defend the respective rights of their people. Mr. President, sir, the Republic of Zambia is cognizant of the fact that at the center of the conflict is the territorial dispute and rejection of the partition plan since the creation of the State of Israel in 1948. The United Nations has historically attempted to resolve this conflict through political processes, which culminated in various peace treaties and Security Council resolutions, such as the Oslo Accords and the Security Council resolutions 242 of 1967 and 338 of 1973. There is also the historic exchange of letters between the late former Prime Minister of Israel, may his soul rest in peace, Isaac Rabin, and the late former Palestinian Liberation Organization Chairman, may his soul rest in peace, the late Yasser Arafat, dated 9 September 1993. This exchange, Your Lordship, and members of the Court, which carries no time limit on its validity, contains mutual declarations of recognition, reciprocal commitments to negotiate peace. To this end, the parties, and I mean both Israel and Palestine, are expected to refrain from undermining or prejudicing the accords through unilateral or third-party initiatives or actions, and from any other initiatives and attempts to impose a solution that seeks to circumvent the agreed-upon negotiations. Mr. President, members of the Court, there is an argument that negotiations have proved to be ineffective in the past, and therefore the resort to advisory opinions. The Republic of Zambia respectfully submits that the Israelis, the Palestinians, regional states, and the broader international community, and indeed the United Nations Security Council, should consider the reasons why the negotiations failed in the first place and address that issue before resorting to a solution that seeks to bypass the agreed-upon negotiations. In the case of the Israeli-Palestinian conflict, if it is established that negotiations have been ineffective, it may call then for an addendum to the Oslo I Accord to amend Article 15, which provides for negotiations, and replace that clause with another mode of dispute settlement. Mr. President, in any event, one may also argue that the advisory opinion by this court on the legal consequences of the construction of the wall in the occupied Palestinian territory in 2004 was also ineffective. Should it then be argued also that the international community must abandon advisory opinions of this court? We submit that postmortems are important in evaluating the challenges and limitations of the dispute settlement mechanisms that are applied to resolve the problem before resorting to another mode. Mr. President and members of the court, it is our firm submission that the Oslo Accords remain the only valid, agreed legal source of authority for the division of control, powers, and responsibilities between Palestine and Israel over the various parts of the territories. Article 15 of the Oslo I Accord prescribes negotiations as the mode of resolving disputes. No other legal or normative framework, whether through international conventions, declarations, or UN resolutions, has substituted the agreed-upon, still valid legal framework of the Oslo Accords, unless and until the same are amended. Zambia proposes that the final determination of this matter would be for the parties to resolve their dispute through a settlement means of their choice, which is negotiations. The just and sustainable two-state solution cannot be imposed from the outside through an advisory opinion. The Republic of Zambia fully supports this recognized and established framework for the resolution of the Israeli-Palestinian conflict. The court needs to safeguard the established legal framework as endorsed by the parties' bilateral agreements and reflected in repeated United Nations resolutions, both with respect to the administration of the territory pending a negotiated outcome, and with respect to reaching a permanent status solution or resolution that addresses legitimate needs and aspirations of both sides. The parties have an obligation under Article 31, Clause 7 of the 1995 Palestinian Interim Agreement on the West Bank and the Gaza Strip, which is Oslo II Accord, not to initiate or take any step that would change the status of the West Bank and the Gaza Strip pending the outcome of the permanent status negotiations. Mr. President, members of the court, This court did announce or pronounce itself on the importance of continued negotiations in its advisory opinion of 2004 on the legal consequences of the construction of the wall in the occupied Palestinian territory. The court encouraged efforts to achieve a negotiated solution to the conflict and the establishment of a Palestinian state existing side by side with Israel for peace and security for all in the region. This court, while noting that illegal actions and unilateral decisions were taken on both sides, confirmed the continued validity of the legal framework by stipulating that this situation can be ended only through implementation of the agreements in good faith. Mr. President, members of the court, as we conclude, we wish to submit that the court is neither the only dispute resolution mechanism available, nor is it the best in all circumstances. Let me repeat that one. As we conclude, we wish to submit that the court is neither the only dispute resolution mechanism available, nor is it the best in all circumstances. The best dispute resolution mechanism is one that delivers optimal and sustainable solutions depending on the peculiar circumstances of each case. And there is certainly no one-size-fits-all. Where, for instance, the objective of the dispute resolution mechanism is to blame one party or the other, or to solely determine a winner or a loser, then we have no doubt that the court is the best forum. Mr. President, those of us that have practiced law for many years know how in determining a winner and a loser, the court decisions have, in almost all cases, left permanently ruined relationships between neighbors on a difference which could have been resolved in a better way by adopting alternative dispute mechanisms such as a negotiated settlement, conciliation, or mediation. In conclusion, therefore, the Republic of Zambia reiterates the call for relentless efforts aimed at achieving peace in the Middle East based on the principles of a two-state solution. Both Israel and Palestine have a duty to respect international human rights law and international humanitarian law. Therefore, any recourse to the conflict should not be one that puts a blame squarely on one party, but rather one that advances a negotiated solution, which culminates in a two-state solution. The Republic of Zambia surmises that the court should not exercise its jurisdiction under Article 65 of the statute, but rather give deference and sanctity to the bilateral agreements existing between the two states, and indeed give deference to the doctrine of party autonomy and pacta sunt servanda. We argue in the alternative, we conclude in the alternative, that should the court decide to exercise its jurisdiction to render the sought advisory opinion, which, as we said, it has the jurisdiction, then the opinion should encourage and assist the parties to respect the legal commitments, including conducting credible negotiations, and not make it more difficult for them to do so. This is also anchored on the fundamental international legal principle of pacta sunt servanda. In this way, Your Lordship, the Court would essentially be upholding the sovereign rights of the two parties. Mr. President, I thank you for your attention.
I thank the delegation of Zambia for its presentation. I invite the next participating delegation, the League of Arab States, to address the Court, and I call Mr. Abdul Hakim Al-Rifai to the podium.
Thank you, Mr. President, honourable members of the Court. It's a great honour and privilege to appear before you today on behalf of the League of Arab States. I would like to read a statement by His Excellency, Mr. Ahmed Abul Gheit, Secretary General of the League of Arab States. The League of Arab States attaches high importance to the present proceedings, hoping that they contribute to safeguarding the principles of international law, to uphold the inalienable rights of the Palestinian people to self-determination, and end the last oppressive, expansionist, apartheid, settler, colonial occupation still standing in the 21st century. The persistence of this occupation, acts of genocide, ethnic cleansing, war crimes, crimes against humanity, displacement of populations, imprisonment of Palestinians behind illegal segregation walls, expansion of illegal settlements, creating new political realities on the ground, aiming at complicating the dismantling of the occupation. All will never discourage Palestinians from claiming their legitimate, inalienable rights. The insistence on placing Israel above the law through the politicization of accountability and adopting double standards in the application of justice is a direct threat to international peace and stability. Ending Israel's total impunity and subjecting it, like any other state, to the universal rules of international law will help annul its pretexts to systematically reject peace initiatives, the most serious of which is the Arab Peace Initiative of 2002, which offered full normalization of relations with all Arab states in exchange of Israel only respecting its already established obligations under the bodies of international law, human rights laws, and the United Nations Security Council and General Assembly resolutions. This prolonged occupation is an affront to international justice. The failure to bring it to an end has led to the current horrors perpetrated against the Palestinian people, amounting to genocide. There can be no moral or juridical justification for occupying lands, killing, terrorizing, and displacing their populations. The League of Arab States trusts the esteemed court will confirm the illegality of this occupation and unambiguously rule on the legal consequences for all parties, especially those who turn a blind eye, facilitate, assist, or participate in any way in perpetuating this illegal situation. Only the rule of law, not the prevailing law of the jungle, will pave the way to peace in the whole region. Ending the occupation is the gateway to peaceful coexistence. Thank you very much for your kind attention. I now respectfully request, Mr. President, that you call on Dr. Ralph Wild, senior counsel and advocate, to address the legal questions before the court. Thank you.
I thank Mr. Rifai. I now give the floor to Mr. Ralph Wild. You have the floor, sir.
Mr. President, distinguished members of the Court, it's a great honour and privilege to appear before you and to represent the League of Arab States. The Palestinian people have been denied the exercise of their legal right to self-determination through the more than century-long violent, colonial, racist effort to establish a nation-state exclusively for the Jewish people in the land of mandatory Palestine. When this began after the First World War, the Jewish population of that land was 11%. Forcibly implementing Zionism in this demographic context has necessarily involved the extermination or forced displacement of some of the non-Jewish Palestinian population, the exercise of domination over and subjugation, dispossession and immiseration of remaining non-Jewish Palestinians, the emigration to that land of Jewish people, regardless of any direct personal link, and the denial of Palestinian refugees the right to return, all operating through a racist distinction privileging Jewish people over non-Jewish Palestinian people. This has necessitated serious violations of all the fundamental Jus Cogens and erga omnes norms of international law. The right of self-determination, the prohibitions on aggression, genocide, crimes against humanity, racial discrimination, apartheid and torture, and the core protections of IHL. Today, I will address, first, violations of international law arising out of the regime of racial domination, apartheid, perpetrated against the Palestinian people across the entire land of historic Palestine. And then, second, the existential illegality of Israel's occupation of the Palestinian Gaza Strip and West Bank, including East Jerusalem, since 1967. As a necessary prerequisite, I must begin with this special right granted to the Palestinian people in the League Covenant. The legal right of self-determination of the Palestinian people originates in the sacred trust obligations of Article 22 of the League Covenant, part of the Versailles Treaty. Palestine, an A-class mandate under British colonial rule, was, after the First World War, supposed to have its existence as an independent state provisionally recognised, a sui generis right of self-determination. The UK and other members of the League Council attempted to bypass this, incorporating the 1917 Balfour Declaration commitment to establishing a national home for the Jewish people in Palestine into the instrument stipulating how the mandate would operate. However, the Council had no legal power to bypass the covenant in this way. It acted ultra vires, and the relevant provisions were legally void. There was and is no legal basis in that mandate instrument for either a specifically Jewish state in Palestine or the UK's failure to discharge the sacred trust obligation to implement Palestinian self-determination. After the Second World War, a self-determination right applicable to colonial peoples generally crystallized in international law. For the Palestinian people, this essentially corresponded to and supplemented the pre-existing covenant right regarding the same single territory. The 1947 proposal to partition Palestine was contrary to this, the Arab rejection and affirmation of the legal status quo. In 1948, then, Palestine was, legally, a single territory with a single population enjoying a right of self-determination on a unitary basis. Despite this, a state of Israel specifically for Jewish people was proclaimed in 1948 by those controlling 78%, more than three-quarters of Palestine, accompanied by the forced displacement of a significant number of the non-Jewish Palestinian population, the Nakba catastrophe. This illegal secession was an egregious violation of Palestinian self-determination. Israel's statehood was recognized, and Israel admitted as a UN member despite this illegality. Israel is not the legal continuation or successor of the mandate. This violation of Palestinian self-determination is ongoing and unresolved. Two key elements are, first, Palestinian people not displaced from the land proclaimed to be of Israel in 1948 and their descendants have been forced to live as citizens, presently they constitute 17.2%, of a state conceived to be of and for another racial group, under the domination of that group, necessarily treated as second class because of their race. Second, Palestinian people displaced from that land and their descendants cannot return. These are serious breaches of the right of self-determination, the prohibitions of racial discrimination and apartheid, and the right of return. They must end immediately. As if this ongoing Nakba was not catastrophic enough, in 1967, Israel captured the remaining 22% of historic Palestine, the Gaza Strip and West Bank, including East Jerusalem, the Nakba. It's maintained that use of force to remain in control for the 57-year period since. For more than half a century then, a state defined to be of and for Jewish people exclusively has governed the entire land of historic Palestine and the Palestinian people there. And the regime of racial domination, apartheid, and denying return has been extended throughout. In the case of Palestinians living in the occupied territory, this has involved the same serious violations of international law, supplemented by serious violations of norms applicable in occupied territory. Indeed, these people are subject to an even more extreme form of racist domination, as they aren't even citizens of the state exercising authority over them. Even in East Jerusalem, which Israel has purported to annex, the majority non-Jewish Palestinian residents don't have citizenship, whereas Jewish residents, including illegal settlers, are citizens. Just as in territorial Israel, in occupied territory, these serious violations concerning how Israel exercises authority over the Palestinian people must end immediately. However, here, a more fundamental matter must also be addressed: the illegality of the exercise of authority itself. The enduring Palestinian right of self-determination means that the Palestinian people and the state of Palestine, not Israel, are sovereign over the territory Israel captured in 1967. For Israel, the land is extraterritorial and, given what I said about the mandate, territory over which it has no legal sovereign entitlement. Despite this, Israel has purported to annex East Jerusalem and taken various actions there and in the rest of the West Bank, constituting de jure and de facto purported annexation, including implanting settlements. It is Israeli policy that Israel should be not only the exclusive authority over the entire land between the river and the sea, but also the exclusive sovereign authority there. This constitutes a complete repudiation of Palestinian self-determination as a legal right, since it empties the right entirely of any territorial content. Actualizing this through de facto and de jure purported annexation is, first, a serious violation of Palestinian self-determination, and second, because it's enabled through the use of force, a violation of the prohibition on the purported acquisition of territory through the use of force in the law on the use of force, and so an aggression. Serious violations of further areas of law regulating the conduct of the occupation are also being perpetrated, notably the prohibitions on implanting settlements and altering, unless absolutely prevented, the legal, political, social and religious status quo. The occupation is therefore existentially illegal because of its use to actualize purported annexation. To end this serious illegality, it must be terminated. Israel must renounce all sovereignty claims and all settlements must be removed immediately. However, this is not the only basis on which the occupation's existential legality must be addressed. We need to delve deeper into both the law of self-determination and the law on the use of force. Beginning with self-determination, this right, when applied to the Palestinian people in the territory Israel captured in '67, is a right to be entirely self-governing, free from Israeli domination. Consequently, the Palestinian people have a legal right to the immediate end of the occupation, and Israel has a correlative legal duty to immediately terminate the occupation. This right exists and operates simply and exclusively because the Palestinian people are entitled to it. It does not depend on others agreeing to its realization. It is a right. It's a repudiation of trusteeship, whereby colonial peoples were ostensibly to be granted freedom only if and when they were deemed ready because of their stage of development determined by the racist standard of civilization. The anti-colonial self-determination rule replaced this with a right based on the automatic, immediate entitlement of all people to freedom, without preconditions. In the words of General Assembly 1514, inadequacy of preparedness should never serve as a pretext for delaying independence. Some suggest that the Palestinian people were offered and rejected deals that could have ended the occupation, and therefore Israel can maintain it pending a settlement. Even assuming arguendo the veracity of this account, the deals involved a further loss of the sovereign territory of the Palestinian people. Israel cannot lawfully demand concessions on Palestinian rights as the price for ending its impediment to Palestinian freedom. This would mean Israel using force to coerce the Palestinian people to give up some of their peremptory legal rights, illegal in the law on the use of force, and necessarily voiding the relevant terms of any agreement reached. The Palestinian people are legally entitled to reject a further loss of land over which they have an exclusive legal peremptory right. Any such rejection makes no difference to Israel's immediate legal obligation to end the occupation. Turning to the law on the use of force, Israel's control over the Palestinian territory since 1967 as a military occupation is an ongoing use of force. As such, its existential legality is determined by the law on the use of force as a general matter beyond the specific issue of annexation. Israel captured the Gaza Strip and West Bank from Egypt and Jordan in the war it launched against them and Syria. It claimed to be acting in self-defense, anticipating a non-immediately imminent attack. The war was over after 6 days. Peace treaties between Israel and Egypt and Jordan were subsequently adopted. Despite this, Israel maintained control of the territory, continuing the use of force enabling its capture. Israel's 1967 war was illegal in the Jus ad bellum, even assuming, arguendo, its claim of a feared attack. States can't lawfully use force in non-immediately imminent anticipatory self-defense. Alternatively, assuming, again arguendo, that the war was lawful, the justification ended after 6 days. However, the Jus ad bellum requirements continued to apply to the occupation as itself a continuing use of force. In 1967, with self-determination well established in international law, states could not lawfully use force to retain control over a self-determination unit captured in war unless the legal test justifying the initial use of force also justified, on the same basis, the use of force in retaining control. Moreover, this justification would need to continue not only in the immediate aftermath, but for more than half a century. Manifestly, this legal test has not been met. Israel's exercise of control over the Gaza Strip and West Bank through the use of force has been illegal in the Jus ad bellum since the capture of the territory, or at least very soon afterwards. The occupation is therefore, again, existentially illegal in the law on the use of force and aggression, this time as a general matter, beyond illegality specific to annexation. To terminate this serious violation, the occupation must likewise end immediately. What of Israel's current military action in Gaza? This is not a war that began in October 2023. It's a drastic scaling up of the force exercised there and in the West Bank on a continual basis since 1967. A justification for a new phase in an ongoing illegal use of force cannot be constructed solely out of the consequences of violent resistance to that illegal use of force. Otherwise, an illegal use of force would be rendered lawful because those subject to it violently resisted. Circular logic with a perverse outcome. More generally, Israel cannot lawfully use force to control the Palestinian territory for security purposes pending an agreement providing security guarantees. States can only lawfully use force outside their borders in extremely narrow circumstances. Beyond that, they must address security concerns non-forcibly. The USA, UK, and Zambia suggested here that there is a sui generis applicable legal framework, an Israeli-Palestinian lex specialis. This somehow supersedes the rules of international law determining whether the occupation is existentially lawful. Instead, we have a new rule, justifying the occupation until there is a peace agreement meeting Israeli security needs. This is the law as these states would like it to be, not the law as it is. It has no basis in Resolution 242, Oslo, or any other resolutions or agreements. Actually, you are being invited to do away with the very operation of some of the fundamental peremptory rules of international law itself. As a result, the matters these rules conceive as rights vested in the Palestinian people would be realized only if agreement is reached and only on the basis of such agreement. At best, if there is an agreement, this means one that need not be compatible with Palestinian peremptory legal rights, determined only by the acute power imbalance in Israel's favor. At worst, if there is no agreement, this means that the indefinite continuation of Israeli rule over the Palestinian people in the OPT on the basis of racist supremacy and a claim to sovereignty would be lawful. This is an affront to the international rule of law, to the UN Charter imperative to settle disputes in conformity with international law, and to your judicial function as guardians of the international legal system. A final potential basis sometimes invoked to justify continuing the occupation should be addressed. Occupation and human rights law, applicable to illegal and lawful occupations alike, oblige Israel to address security threats in occupied territory. However, they only regulate the conduct of an occupation when it exists. They don't also provide a legal basis for that existence itself. Existential legality is determined by the law of self-determination and the jus ad bellum only. There is no backdoor legal basis for Israel to maintain the occupation through the imperatives of occupation and human rights law. In sum, the occupation of the Palestinian Gaza Strip and West Bank, including East Jerusalem, is existentially illegal on two mutually reinforcing bases. First, the law on the use of force. Here, the occupation is illegal both as a use of force without valid justification and because it's enabling an illegal purported annexation. As such, it is an aggression. Second, the law of self-determination. Here, it's illegal again because of the association with illegal purported annexation, and also, more generally, because it is quite simply an exercise of authority over the Palestinian people that by its very nature violates their right to freedom. This multifaceted existential illegality involving serious violations of peremptory norms has two key consequences. First, the occupation must end. Israel must renounce its claim to sovereignty over the Palestinian territory. All settlers must be removed immediately. This is required to end the illegality, to discharge the positive obligation to enable immediate Palestinian self-administration, and because Israel lacks any legal entitlement to exercise authority. Second, in the absence of the occupation ending, necessarily everything Israel does in the Palestinian territory lacks a valid international legal basis and is, therefore, subject to the Namibia exception, invalid. Not only those things violating the law regulating the conduct of the occupation. Those norms entitle and require Israel to do certain things. But this doesn't alter the more fundamental position from the law on the use of force and self-determination that Israel lacks any valid authority to do anything, and whatever it does is illegal, even if compliant with or pursuant to the conduct regulatory rules. I will close by quoting Palestinian academic and poet Rifat Al-Ariyah from his final poem posted 36 days before he was killed by Israel in Gaza on the 6th of December 2023. If I must die, you must live to tell my story. If I must die, let it bring hope. Let it be a story. Thank you for your attention.
I thank the delegation of the Arab League for its presentation. And before I invite the next delegation to make its oral statement, the court will observe a break for 10 minutes. The sitting is suspended.